Section 91 of the Companies Act, power to close the register of members, debenture holders, or other security holders. Section 91 of the Companies Act grants companies the authority to temporarily close certain registers, such as those of members, debenture holders, and other security holders. This section establishes rules to ensure that the closure of these registers is conducted in a fair, transparent, and legally compliant manner, protecting the interests of stakeholders while allowing companies to manage their administrative processes. Below is a comprehensive explanation of the provisions under Section 91. Subsection 1. Authority to close registers. Registers covered under this section. The registers that may be closed under Section 91 include the following. 1. Register of members, shareholders. This register includes the details of all shareholders in the company, such as their names, addresses, and the number of shares held. 2. Register of debenture holders. This register contains the details of individuals or entities that hold debentures issued by the company. 3. Register of other security holders. This includes individuals or entities who hold other securities issued by the company, such as bonds or any other financial instruments. Time limitations on closure. A company is permitted to close these registers for specific periods, subject to strict limitations to ensure that the process does not interfere with the rights of the stakeholders. These limitations include 1. Maximum period of closure in a financial year. The company is allowed to close the registers for a cumulative total of 45 days within a single financial year. This means the company cannot exceed this duration for the combined periods of closure during the year. 2. Continuous period of closure. Any single closure of the registers cannot exceed 30 consecutive days. This ensures that stakeholders have access to the necessary information for a reasonable period and prevents prolonged periods of inaccessibility. Requirement of prior notice. Before closing any of these registers, the company must provide a prior notice to the stakeholders, ensuring transparency and allowing them to make necessary arrangements. The notice period must comply with the following guidelines. 1. Minimum notice period. The company must issue notice at least 7 days before the proposed closure of the registers. This gives stakeholders a fair amount of time to prepare and take any necessary actions. 2. Shorter notice for certain companies. If the company is listed on a recognized stock exchange or is planning to list its securities, the Securities and Exchange Board of India, SEBI, may specify a shorter notice period. In this case, the company must comply with the SEBI's requirements, which could be less than the standard 7-day notice. Manner of notification. The notice about the closure must be issued in the prescribed manner as specified under the Companies Act and any relevant rules. This includes ensuring that the notice is published in the appropriate manner to reach all relevant stakeholders, including shareholders, debenture holders, and security holders. Subsection 2. Penalties for non-compliance. Instances of non-compliance. If a company does not adhere to the requirements under this section, such as failing to give the appropriate notice or exceeding the allowed closure periods, it will be considered in violation of the Companies Act. The following are examples of non-compliance. 1. Closing any of the registers without providing the required prior notice. 2. Providing a notice that is shorter than the prescribed notice period. 3. Keeping the registers closed for a continuous period exceeding 30 days. 4. Exceeding the aggregate closure limit of 45 days in a financial year. Liability of the company and its officers. In cases where a company fails to comply with the provisions of Section 91, both the company and its officers are subject to penalties. The penalties apply to every officer in default, emphasizing the responsibility of the company's management to ensure compliance. Penalty amount. The penalty for non-compliance under Section 91 is as follows. 1. Daily penalty for improper closure. The company will incur a penalty of 5,000 rupees for every day the register remains improperly closed. This penalty is imposed for each day the closure exceeds the prescribed limits or occurs without proper notice. 2. Maximum penalty. The total penalty imposed on the company for such non-compliance cannot exceed 1 lakh rupees. Similarly, the officers in default will also face penalties under this provision. Purpose and objectives of Section 91. Fair access for stakeholders. One of the key objectives of Section 91 is to ensure that the closure of registers does not restrict stakeholders' access to essential information. The limitations on the duration of closures and the notice requirements are designed to guarantee that stakeholders, such as shareholders and debenture holders, have adequate time to access the information they need for decision-making purposes. Protection against misuse. By imposing limits on the closure periods, Section 91 prevents companies from using frequent or prolonged register closures as a means of obstructing stakeholder rights. For example, if a company were allowed to close its registers for excessive periods, it could delay or obstruct voting rights or prevent stakeholders from inspecting the company's records. This section ensures that such practices cannot be used to the detriment of stakeholders. Regulatory oversight. The provision empowers SEBI to regulate the closure periods for listed companies or companies planning to list on a recognized stock exchange. By providing SEBI with the authority to specify shorter notice periods or impose additional conditions, the section aligns corporate practices with investor protection norms, particularly in the context of publicly traded companies. Key takeaways. 1. Timely notice. Companies must issue an adequate notice prior to closing their registers, ensuring that stakeholders are well informed and able to make the necessary arrangements. 2. Limited closure periods. The law limits the duration of register closures, striking a balance between the operational needs of the company and the rights of stakeholders. The total closure period in a financial year cannot exceed 45 days, and no single closure period can exceed 30 consecutive days. 3. Penalties for default. Non-compliance with the provisions of Section 91 results in financial penalties for both the company and its officers, ensuring accountability and encouraging adherence to the regulatory framework established by the Companies Act. For more details, contact us.